Next page. Chapter 15 Realization of the Estate Assets. _ 15 Realization of the Estate Assets. 15.1 Procedure for realization of estate assets generally. Trustees' role: must realize estate assets for creditors, including solvent spouses' property unless released. Disposal of assets. Generally, trustee must sell assets for value. Exceptions: creditors can authorize disposal of an asset without receiving value if it serves the estate's interests. Janssen van Rensburg v. Muller 1996, 2, SA 557, A 564-5. If partial realization satisfies all claims, remaining assets need not be sold. Jacobs v. Hessels 1984, 3, SA 601, T. Assets that may not be sold. Insolvents wearing apparel and bedding, S 82-6. Household furniture, tools, and essential means of subsistence, except creditors or master may limit retention, IBID. Waiver of protection. Insolvent may renounce protection to allow sale, ex parte Anthony 2000, 4, SA 116, C. 125. Contradictory ruling: protection benefits debtors family/public, and cannot be waived, ex parte Cross 2015, 1, SA 405, NWM, ex parte Van Dyke 2015, JDR 0667, GP. Restraint on alienation. Trustee cannot sell assets with a restriction on transfer. Engelbrecht v. Mundels Trustee 1934 CPD 111. Pactum de non cedendo, agreement not to cede a claim, binds trustee if 1. The agreement explicitly applies in insolvency. Lippens v. Lavels Corporacy 1989, 3 SA 891, T2. Contained in a lease, S 37-5. 3. Forms part of the contract that created the right. Capespan v. Any Name 451, 2008, 4, SA 510, C. Rights created as non-transferable ab initio cannot be ceded, even involuntarily. Born-Free Investments 364 v. Firstrand Bank 2014, 2, or SA 127, SCA. _ 15.1 1 Manner of realization. Trustee must follow creditor's directions from the second meeting, S 82-1. If no directions, assets must be sold by public auction or tender, IBID. _ 15.1 2 Requirements for public auction/tender sales. Notice requirements. Gazette notice and other notices required by the master, S 82-1. Description must be accurate. Muller v. de Wet No 2001, 2, SA 489, W. 494-5. Sale by public tender. Each tender must be submitted in duplicate in a sealed envelope to the master/magistrate, S 82-2. Master/magistrate must keep tenders unopened until submission period ends, IBID. Trustee, or representative, has the right to attend the opening, IBID. After opening, no further offers allowed. Trustee must accept the best tender, or reject all tenders and sell by public auction, S 82-5, unless otherwise directed by creditors or master. _ Let me know if you need further refinements. Next page. Chapter 15 Realization of the Estate Assets. 15.1 Procedure for realization of estate assets generally. The trustee must realize estate assets for the benefit of creditors, including property of the solvent spouse that has vested in the trustee and not been released. The sale must be for value unless creditors authorize disposal without value in good faith, and in the estate's interest. Janssen van Rensburg v. Muller 1996, 2, SA 557, A 564-5. Sale is unnecessary, because partial realization covers all debts and sequestration costs. Jacobs v. Hessels 1984, 3, SA 601, T. The trustee may not sell Insolvents clothing and bedding, S82-6. Household furniture, tools, and essential items unless creditors or the master decide otherwise, IBID. Assets burdened with a restraint on alienation, Engelbrecht v. Mundell's Trustee 1934 CPD 111. Assets subject to a valid pactum de non cedendo unless the agreement explicitly states it applies in insolvency. Lithens v. Lavel's Corpusy BPK 1989, 3 SA 891, t. The restriction is in a lease S37-5. The right was created ab initio as non-transferable, Capespan, proprietary, limited v. Any name 451, proprietary, limited 2008, 4, SA 510, c. Born Free Investments 364, proprietary, limited v. FirstRand Bank Limited, 2014, to all SA 127, SCA, confirmed that a right created ab initio as non-transferable binds even liquidators. 15.1 Manner of realization. Trustee must follow directions from creditors at the second meeting S82-1. If no directions are given, assets must be sold by public auction or public tender, IBID. 15.12 Requirements for public auction/tender sales. Public auction/tender sales require prior notice in the Gazette, and other notices per master's requirement, S82-1. Assets must be accurately described, Malavida Wetno and others 2001, 2, SA 489, W, 494-5. If creditors provide no sale conditions, the master determines them, S82-1. Public tender process. Tenders submitted in duplicate, sealed, to the master or a designated magistrate, S82-2. Opened only after submission deadline in trustee's presence, IBID. One copy filed with the master, the other sent to the trustee, IBID. Once tenders are opened, no further offers allowed, S82-5. The trustee must either accept the best tender or reject all and proceed with a public auction, IBID. 15.1.3 Sale in contravention of the Act. A sale violating S82 remains valid if the buyer acted in good faith, S82-8, Nord v. Serpentine No. 1978, 1, SA 633, 0. The trustee is liable for twice the estate's loss due to wrongful actions, S82-8. Good faith requires the buyer to lack knowledge that the trustee had no authority, Mukri v. Smith No. 1989, 2, SA 707, c. The buyer must provide proof of good faith, Malavida Wet No. 2001, 2, SA 489, W. If the buyer knew of the trustee's lack of authority, S82-8 protection does not apply, Mukri v. Smith No. Supra. S82-8 also applies to sales by liquidators without authority, Chata Developments, proprietary, limited v. Vartakluth Marina Estates, proprietary, limited 2015, 5, SA 138, SCA, via S339 of Companies Act 61 of 1973. 15.1.4 Purchase of assets by trustee. The trustee, auctioneer, their spouses, partners, employers, employees, or agents cannot acquire estate assets unless the court confirms the purchase, S82-7. Court confirmation required even if purchase is in a representative capacity, Estate Jamodian v. Registrar of Deeds 1933 CPD 348. Courts generally confirm sales to the trustee if they were open, fair, and the highest bid at a well-advertised auction, Estate Huff 1919 CPD 160. Acquisition is unenforceable without confirmation, Estate Jamodian, Supra. If an invalidly acquired asset is resold in good faith and for value, the new buyer's acquisition is valid, S82-8. The person who improperly sold or transferred the asset must reimburse the estate twice its loss, IBID. 15.1.5 Sale of assets before second meeting of creditors. The trustee generally must wait for creditor directions from the second meeting before selling estate assets. However, an early sale may be permitted if the trustee provides a written recommendation to the master with reasons, S80 bis 1. The master authorizes the sale and sets conditions, S80 bis 2. If a preferential right applies, sale requires consent of the preferential right holder or a guarantee against loss, IBID. _ This summary maintains the legal principles, case law, and statutory references while condensing the text significantly. Let me know if you need further refinement. Next. Page 15.2 Special Rules Governing Realization of Particular Assets. 15.2.1 Goods subject to statutory lien. Certain lien holders can sell impounded goods without court intervention. Example, the Commissioner of the South African Revenue Service, SARS, can sell property impounded under the Customs and Excise Act 91 of 1964, if the debt remains unpaid for 3 months, S114(1). 15.2 Rights acquired from the state, lease, license, etc. The trustee must follow the governing statute when dealing with rights acquired through leases, licenses, or land allotments from the state, S82(1) Insolvency Act. 15.2.3 Interest in a close corporation. Close Corporations Act 69 of 1984 governs the realization of an insolvent's interest in a close corporation. The trustee may sell the interest to the corporation if the insolvent is not the sole member. The other members, not necessarily in proportion to their interests. A qualifying third party under S29. If selling to a third party, S34(2). The trustee must notify the corporation, providing details of the proposed purchaser. The corporation or members have 28 days to match the offer. If no response, the sale to the third party proceeds. 15.2.4 Movable property held as security. Definition: Movable property includes all non-immovable assets, S2 Insolvency Act. Forms of security: special mortgage, notarial bond under the Security by Means of Movable Property Act 57 of 1993, or prior notarial bonds under the Notarial Bonds, Natal Act 18 of 1932. Landlord's legal hypothec. Pledge. Right of retention. Notice of movable security. Creditors must notify the master and trustee in writing before the second creditors' meeting, S83(1). 2. Realization of security by creditor. Marketable securities, for example stocks, bills of exchange, financial instruments. The creditor may sell these via authorized financial institutions after notifying the trustee, S83(2). 8. Transactions on a market infrastructure or under a master agreement, S35A, 35B2, follow special rules. Bills of exchange must be realized as approved by the trustee or master, S83(8)B. Other movable property. The trustee can take over the asset at an agreed value or at the full claim amount, S83(3). If the trustee does not exercise this option within 7 days, the creditor may sell the property at public auction, S83(3)(8)D. Rights of action cannot be sold without trustee or master approval, S83(8)C. Sale details must be communicated to all creditors, S83(9). After sale, the creditor must pay net proceeds to the trustee immediately, S83(10). Claim must be proven under S44 with a statement of proceeds and preference basis, S83(5). If the trustee disputes preference, the creditor may object to the trustee's account when lodged, S17.6. Apply for a court order for immediate payment, S83(10). Key case: Rufin Finance Company, Proprietary, Limited v. Cohen and others NNO 1991, 2, SA 345, W. The creditor can demand payment even if the trustee disputes the claim's validity. However, provision must be made for repayment if the claim is later invalidated. Trustee's responsibility: deduct estate costs from sale proceeds before creditor payment, S16, Part 1I. Key case: Alert Steel, Proprietary, Limited in liquidation, v. Mercantile Bank Limited 2022 JDR 1743, SCA. The Supreme Court of Appeal held that liquidators who distribute payments before the liquidation, and distribution account is confirmed do so at their own risk. 3. Security not realized by creditor. If not realized before the second creditor's meeting, the creditor must deliver the asset to the trustee, S83(6). If not delivered within 3 days, the trustee can demand it. If non-compliance continues, the master may order the sheriff to seize the asset. Rights retention. Creditors do not lose security rights if they notify the trustee in writing and prove their claim, S47. Once delivered, the creditor must prove the claim, valuing the asset, S83(7), 44.4. The trustee may take over the property at the creditor's valuation, S83(11). If not taken over within 3 months, the asset is sold for the benefit of all secured creditors, S83(11). 4. Non-compliance with the Act. Failure to comply does not exempt the creditor from surrendering proceeds. Key case, Venta Noviafin, Proprietary, Limited 1996, 1, SA 826. A creditor who fails to follow S83 formalities must still pay proceeds to the trustee. The Insolvency Act allows secured creditors to retain and sell assets, but proceeds must be handed over. The court rejected the argument that a creditor could gain an advantage by ignoring statutory formalities. Key case, Standard Bank of South Africa Limited v. Townsend, and others 1997, 3, SA 41, W. Failure to comply does not bar the creditor from proving and claiming payment from the estate. This summary provides a structured breakdown of special rules governing asset realization, focusing on key legal provisions, procedures and case law. Next page. Study notes, immovable property held as security and realization of solvent spouse's property. 15.2.5 Immovable property held as security. Realization by trustee. Unlike movable property, immovable property held as security must generally be realized by the trustee. Realization is done according to directions given at the second meeting of creditors or by public auction/tender, in the absence of directions. Trustee can take possession before realizing, even if subject to a right of retention. Case law, Ruin and Der v. van Rensburg No 1996, 4, SA 271, A. Ex parte van de Merwe 2008, 6, SA 451, W. 457. Rights of retention and legal hypothec. Holder retains security if they notify the trustee when delivering the property, and later prove a claim, S47. Competing real rights and mortgage bonds. Immovable property with a mortgage bond may also have other real rights, for example, fideikommissum, usufruct, lease under Hogarth for Coop rule, sharecropper's right. Ranking of rights determines sale process. If other real right is preferred, property must be sold subject to it. Case law, Bell & Co. v. Ivans, and Edmonds, 1905, 26 NLR 449. If mortgage bond is preferred, property may be sold free of the other right, but only if proceeds would not satisfy the bondholder's claim. Case law, United Building Society Limited, and another No v. Duplessis 1993, SA 75, W. 80. Procedure if mortgage bond is preferred. 1. Attempt sale subject to other right. If proceeds satisfy mortgagee's claim, property must be sold subject to other right. 2. If proceeds are insufficient, holder of the other right can satisfy the mortgagee's claim. If met, property remains subject to the right. If not met, property is sold free of the right. Case law, Van de Viver v. Estate Van de Viver 1932 CPD 45, fideikommissum. Tim v. K 1954, 4, SA 585 T. Lease. United Building Society Limited v. Duplessis, Supra, usufruct. Luba v. Volksgas BPK 1992, 3 SA 868, A. 875, sharecropper's right. Court's view on non-compliance with procedure. Case law, Valkich v. Land and Agricultural Bank of South Africa 1996, 1, SA 17, A. Court accepted the procedure as standard but held that non-compliance does not necessarily invalidate the sale. The onus is on the trustee to prove that a sale subject to the lease would not have yielded a sufficient price. Case law, Shell Rhodesia, Private, Limited v. Eliasov No 1979, 3 SA 915, R 921, obiter. Contrast with Oosthuizen v. Human 1911 EDL 273-280, where lessee bears the onus. Alternative to realization. Trustee may abandon the property to the secured creditor as payment in kind. United Building Society Limited v. Duplessis, Supra, 81. Take over the property at its valued amount when claim was proved, S. 8311. Must occur within 3 months of trustee's appointment or claim proof. If trustee does not take over, property must be realized for the benefit of all secured creditors. 15.3 Realization of solvent spouse's property. Trustees' powers under S21(1). Solvent spouse's property vests in the trustee and may be dealt with as part of the sequestrated estate. Requirement for sale under S21(3). Trustee may realize the solvent spouse's property only if 6 weeks written notice is given to the solvent spouse. Notice is published in the Gazette and a local newspaper. Creditors of the solvent spouse are invited to prove their claims. S21(5). Exceptions to notice requirement. Solvent spouse is outside the Republic. Trustee cannot ascertain spouse's address. Court grants leave to sell without notice. Definition of ostensibly belonged. Not defined in the Act but generally refers to property registered in or possessed by the solvent spouse at the time of vesting. Case law, Van der Burg v. Insolvent Estate Van der Burg 1931 CPD 1. Onus of proof remains on the solvent spouse to prove that property falls within S21(2) exemptions. Case law, Constantinu v. Lipkino 1958, 2, SA 122, 0. Application of S83 to solvent spouse's property. S83-13 extends S83 provisions to the solvent spouse's movable property held as security by a creditor. Next page. Chapter 16 on creditors' claims and their ranking. Creditors' claims and their ranking. 1. Overview of insolvency law and creditors' ranking. Insolvency law ensures that an insolvent debtor's assets are distributed among creditors in a predetermined and fair order of preference. Creditors are classified into 3 types based on ranking: concurrent, secured, and preferred creditors. 16.1 Types of creditors. 16.1.1 Concurrent creditors have no advantage over other creditors. Paid out of the free residue, unencumbered assets after payment of secured and preferred creditors. All concurrent creditors rank equally and share proportionally if the free residue is insufficient. Example, if A has a claim of R6,000 and B has a claim of R4,000 and the free residue is R5,000, each creditor receives 50 cents per rand. A gets R3,000, B gets R2,000. 16.1. 2 Secured creditors hold real security for their claim, such as special mortgage, landlord's legal hypothec, pledge, right of retention. Excludes creditors secured by suretyship, S2, paid out of the proceeds of the encumbered asset after certain expenses. Secured claims ranking higher. If the proceeds are insufficient, they have a concurrent claim for the balance. Singano v. The Master and Another 1996, 2, SA 133, A. Election under S89-2. Secured creditors can choose to rely exclusively on their security, forfeiting rights in the free residue. Eastern Free State Kid Cooperative Limited, v. The Master and Others 1997, 3, SA 899, E. This election is binding and cannot be undone. Absa Bank Limited v. The Master and Others NNO 1998, 4, SA 15, N. they can still claim the remaining amount from a surety, if the security does not cover the full debt. BOE Bank Limited v. Bassage 2006, 5, SA 33, SCA. If a creditor does not make an unequivocal election, they may still share in the free residue. Snyman v. The Master and Others 2003, 1, SA 239, T16.1.3 Preferred creditors. Preferred creditors are paid before concurrent creditors, but after secured creditors. The Insolvency Act provides specific categories of preferred claims. 1. Funeral and deathbed expenses, S96. 2. Costs of sequestration, S97. 3. Costs of execution, S98. 4. Salary/remuneration of employees, S98A. 5. Statutory obligations, S99. 6. Income tax claims, S101. 7. Claims of holders of general and special bonds, S102. Companies Act 71 of 2008 introduces a new preference for the business rescue practitioner's fees and expenses, S135, ranking below execution costs and above employee salaries. Preferred creditors are paid from the free residue, ranking in a statutory order. If a preferred claim exceeds a statutory limit, the remaining amount becomes a concurrent claim. 16.2 Types of security conferring preference. 16.2.1 Special mortgage. Security over immovable property, for example, a bond over a house. Mortgage holder is a secured creditor and ranks above other creditors concerning that asset. 16.2 Landlord's legal hypothec. Right of a landlord to claim arrears rental by attaching the movable property of the tenant on the leased premises becomes enforceable upon sequestration of the tenant's estate. 16.2.3 Pledge. Security over movable property, where the debtor hands possession of the pledged item to the creditor. The creditor has a preferential claim over the pledged assets proceeds. 16.2.4 Right of retention. Creditor retains possession of a movable or immovable property until the debtor settles the claim, for example, an unpaid repairer keeping a car. Prefer ranking over the retained property. 16.2.5 Installment agreement hypothec. Security interest created under an installment sale agreement for assets like vehicles. Secured creditor ranks ahead of concurrent creditors concerning the hypothecated asset. 16.3 Ranking of claims. 16.3.1 Encumbered assets. Secured creditors are paid first from the proceeds of encumbered assets. Proceeds distributed in the following order. 1. Costs of realization expenses incurred in selling the asset. 2. Secured creditors with higher ranking claims. 3. The secured creditor with the specific claim over the asset. 4. If the asset's value is insufficient, the remaining balance is a concurrent claim. 16.3.2 Unencumbered assets, free residue, paid out in the following order. 1. Funeral and deathbed expenses, S96. 2. Costs of sequestration, S97. 3. Costs of execution, S98. 4. Business rescue practitioners' fees, Companies Act 71 of 2008, S135. 5. Employees' salaries and wages, S98A. 6. Statutory obligations, for example, UIF, VAT, paid tax liabilities, S99. 7. Income tax debts, S101. 8. Claims of general and special bondholders, S102. 9. Remaining free residue distributed to concurrent creditors, on a pro rata basis. Key case law. Singer No v. The Master and Another 1996, 2, SA 133. A secured creditor has a concurrent claim for any shortfall if the secured assets proceeds are insufficient. Eastern Free State Cape Cooperative Limited v. The Master and Others 1997, 3, S. 899, E. A secured creditor must make an unequivocal election under S. 1892 when proving a claim. Absa Bank Limited v. The Master and Others NNO 1998, 4, SA 15, N. Once a secured creditor elects to rely solely on security, they cannot later claim from the free residue. BO Bank Limited v. Bassage 2006, 5, SA 33, SCA. A secured creditor can still pursue a surety for any unpaid portion of their debt. Snyman v. The Master and Others 2003, 1, SA 239, T. A vague or conditional election under S. 89(2) does not prevent a secured creditor from claiming from the free residue. Conclusion. Insolvency law prioritizes secured creditors, followed by preferred creditors, and lastly concurrent creditors. Secured creditors rely on encumbered assets, while preferred creditors rank above concurrent creditors in the free residue. The Companies Act introduced a new ranking for business rescue practitioner fees. Creditors must understand their ranking to maximize recovery from an insolvent estate. Next page. Here's a detailed study note summary based on your preferences. 16.2 Types of security conferring preference. 16. Do 1 Special mortgage. Defined in S2, covering mortgage bond hypothecating immovable property, notarial bond over specially described movable property under S1 of the Security by Means of Movable Property Act 57 of 1993, effective the 7th of May 1993. Notarial bond registered before the 7th of May 1993 under S1 of the Notarial Bonds, NATO Act 18 of 1932, repealed by the 1993 Act. Exclusions. General notarial bonds, but they confer preference in the free residue of an estate, 16.3.28. Bonds under S31 of the Ship Registration Act 58 of 1998 are deemed special bonds, S31.5. Section 88 of the Insolvency Act. A bond, except a custing brief, confers no security or preference if the debtor's estate is sequestrated within 6 months after bond registration. The debt was incurred more than 2 months before bond registration. The debt was not previously secured. A conditional debt is incurred when its condition is met. Joint Liquidators of Glen Anil Development Corporation Limited, in liquidation, v. Hill Samuel, S.A., Limited 1982, 1, S.A. 103, A. Purpose: prevent creditors from securing claims just before insolvency, but does not restrict bond registration in general. If part of a debt was secured before, but not the whole amount, only the secured part enjoys preference. Volkskas BPK v. Meester van die Hoegerijkshof, NN Anderno 1987, 4, SA 192, North Carolina. Custing brief exception. A special mortgage bond where the purchaser passes the bond in favor of the seller for the purchase price, or a third-party lender financing the purchase, takes priority over later registered mortgage bonds. In re-insolvent estate of Buisen van der Bill and Meyer v. Sequestrator and Attorney General, 1828-1849, 1 Mens 318. Prescription period: 30 years for debt secured by a special notarial bond, Factor Props 1052 cc, and another v. Land and Agricultural Development Bank of South Africa 2017, 4, SA 495, SCA. Cancellation of a mortgage bond does not alter the prescription period. Botha v. Standard Bank of South Africa Limited 2019, 6, SA 388, SCA. 16. 2. Landlord's legal hypothec. Covers movable property brought onto leased premises by the tenant, crops raised by the tenant, preference in insolvency, S85(2). 3 months rent if rent is monthly or at shorter intervals, 6 months rent if rent is every 1 to 3 months, 9 months rent if rent is every 3 to 6 months, 15 months rent if rent is every 6+ months. Excess claim, landlord holds a concurrent claim for any unpaid balance beyond these limits. Third-party property exclusion. Landlord gets no preference over third-party owned goods on premises. Kleinsektion Twickelings Corporatie BPK, Bank BPK 1988, 3, SA 266, C_. 16. Do 3 Pledge. A valid pledge requires delivery of movable property to a creditor, with an agreement to hold it as security. Incorporeal property is pledged via cession in Securitatem Debitae, Bank of Lisbon and South Africa Limited v. The Master and Others 1987, 1, SA 276, A. A general notarial bondholder gains pledgee status when possession of movables is obtained under a court order via a perfection clause. Development Bank of Southern Africa Limited v. Van Rensburg and Others NNO 2002, 5, SA 425, SCA, Contract Forwarding, Proprietary, Limited v. Chesterfine, Proprietary, Limited and Others 2003, 2, SA 253, SCA, Grobler v. Oosthuizen 2009, 5, SA 500, SCA. _ 16. 2.4 Right of retention. Lien arises automatically by law when a party incurs expenses or labor on another's property. Types of liens. Enrichment liens, based on unjustified enrichment, includes salvage liens, preserve property; improvement liens, increase property value; holder retains property until reimbursed for expenses/labor, limited to the owner's actual enrichment. Example, lessee of urban property has a lien for necessary and useful improvements. Business Aviation Corporation, Proprietary, Limited and Another v. Rand Airport Holdings, Proprietary, Limited 2006, 6, SA 605, SCA. Debtor and creditor liens. Contract-based security for an agreed repair/improvement price. Creditor retains property until full payment is made. Possession rule. A lien generally requires possession of the property. Exception: maritime liens under the Admiralty Jurisdiction Regulation Act 105 of 1983, Euromarine International of Maureen v. Shipberg and Others 1984, 4, SA 647, N_. 16. 2.5 Installment Agreement Hypothec. Applicable where movable property is delivered under an installment sale agreement. The seller holds a hypothec over the property until full payment. On sequestration, seller has a secured claim for the outstanding balance, S84-1. Cross-reference, C7, 2.8 for further details. _ This summary captures key legal principles, legislation, and case law while maintaining a structured format for study purposes. Let me know if you need further refinements. Next page. Ranking of claims in insolvency. General principles. The Insolvency Act ranks claims against an insolvent estate to determine the order of payment. The estate consists of encumbered assets, used first to satisfy secured creditors; unencumbered assets, combined with any remaining funds of the secured claims to pay other creditors; free residue, funds available after secured creditors are paid. Preferred claims are paid first in their order of preference. Concurrent creditors are paid proportionately if free residue is insufficient. If surplus remains after all claims, post-sequestration interest is paid at a prescribed rate. _ Encumbered assets. Initial costs, S89-1, before secured claims, certain costs must be settled. Costs for maintaining, conserving, and realizing the asset. For example, night watchman, auctioneer's commission, sectional title levy, S15B3 AA, of the Sectional Titles Act 95 of 1986. Relevant cases. Now Novi Body Corporate of the Seaways Building and Another 1996, 1 SA 131, A. Barnard Novi Riggs Persoon van Amini NN Ander 2001, 3 SA 973, SCA, Water, sewerage and municipal clearance costs, Eastern Metropolitan Substructure, of the Greater Johannesburg Transitional Council v. Venter, No. 2001, 1 SA 360, SCA 370-1. Trustees' Remuneration, Tariff B, Second Schedule to the Act. Proportionate share of Trustees' Security Costs, Masters' Fees, Third Schedule to the Act. If asset is immovable property. Any tax due for the 2 years before sequestration. Tax from sequestration date to transfer of property. Includes interest and penalties. Steve Tshweta Local Municipality v. Fedbond Participation Mortgage Bond Managers, Proprietary, Limited and another 2013, 3 SA 611, SCA. If a statutory prohibition period is shorter than 2 years, the shorter period applies. City of Johannesburg v. Kaplan No. and another 2006, 5, SA 10, SCA 19-20. Municipal debts, rates and services, are not taxes under S89, but still prefer over mortgage bonds, S118(3) of the Local Government, Municipal Systems, Act 32 of 2000. City of Tshwane Metropolitan Municipality v. Mathababe, and another 2013, 4, SA 319, SCA. S118(3) creates a security right over property, ranking above mortgage bonds. S118(1) is an embargo provision with a time limit. Jordan and others v. City of Tshwane Metropolitan Municipality, and others 2017, 6, SA 287, CC. A new owner is not liable for historical municipal debts under S118(3), as it would be unconstitutional. If free residue cannot cover funeral and deathbed expenses, secured assets bear the shortfall in proportion to their value, S96(4). 2. Secured claims, S95(1). After initial costs, balance of proceeds is used to settle secured claims in order of preference. Interest on secured claims. 2 years pre-sequestration, treated as part of the capital, S89(3). Post-sequestration interest, S95(1). 8% per annum unless a higher contractual rate applies, S103(2). Simple interest, not compound, Boland Bank Limited v. The Master and another 1991, 3 SA 387, A_. Ranking of secured claims. Immovable property. 1. Enrichment lien. 2. Special mortgage bonds, registered in order of priority. 3. Debtor and creditor lien, De Glazer and Sons, Proprietary, Limited v. The Master and another No. 1979, 4, SA 780, C. Land en Landbouw Bank van South Africa v. Kopmanskloof, Besproeingsraad 1992, 1, SA 217, A. 244. Movable property. 1. Enrichment lien. 2. Pledge, including statutory pledges, for example, S30 of Land and Agricultural Development Bank Act 15 of 2002. 3. Special notarial bonds, registered in order of priority. 4. Debtor and creditor lien. 5. Installment agreement hypothec. 6. Landlord's hypothec. Restrictions on security interests. Lien and pledge cannot coexist, both require possession of the asset. Landlord's hypothec cannot exist if asset is hypothecated by a notarial bond under the Security by Means of Movable Property Act 57 of 1993, unless perfected before bond registration. Asset is subject to an installment agreement under the National Credit Act 34 of 2005, S2 of Security by Means of Movable Property Act. Shortfalls in secured claims. If security proceeds are insufficient, secured creditor may claim concurrently for the shortfall. If creditor waives security, they are treated as a concurrent creditor. Next page. 16.3 Ranking of claims. The Insolvency Act establishes the order in which claims against an insolvent estate must be paid. The estate consists of proceeds from both encumbered and unencumbered assets. Encumbered assets, proceeds are used to pay secured claims first. Free residue, any remaining balance from encumbered assets, is combined with proceeds from unencumbered assets to pay other creditors. Payment priority. 1. Preferred claims, paid in order of preference. 2. Concurrent creditors, paid proportionally if funds are insufficient. 3. Post-sequestration interest, payable if all concurrent claims are settled in full. 16. 3.1 Encumbered assets. Initial costs. Section 89(1). The proceeds of an encumbered asset must first cover specific costs before secured creditors are paid. Creditors for these costs cannot claim against the estate. Standard Bank of South Africa Limited v. Townsend, and others 1997, 3 SA 41, W. 58. These costs include maintenance, conservation, and realization costs, for example, security, auctioneer fees, sectional title levy. Now Novi Body Corporate of the Seaways Building and another 1996, 1 SA 131, A. Barnard Novi Rigspersoon Vanamini NN under 2001, 3 SA 973, SCA, Eastern Metropolitan Substructure, of the Greater Johannesburg Transitional Council v. Venter No 2001, 1, SA 360, SCA, 370-1. Trustees' Remuneration, Tariff B, Second Schedule to the Act. A proportionate share of the trustees' security costs. A proportionate share of the master's fees, Third Schedule to the Act. If the asset is immovable property. Taxes due for up to 2 years before sequestration. Taxes from sequestration to transfer date, including interest/penalty. Steve Tashweta Local Municipality v. Fedbond Participation Mortgage Bond Managers, Proprietary, Limited and another 2013, 3 SA 611, SCA, if a law limits a tax embargo to a shorter period than S 89(1, the shorter period applies. City of Johannesburg v. Kaplan No and another 2006, 5, SA 10, SCA, 19-20. Municipal debts for rates and services are not taxes under S 89, but take preference under S 118(3) of the Local Government, Municipal Systems, Act 32 of 2000. City of Tshwane Metropolitan Municipality v. Macababe, and another 2013, 4, SA 319, SCA, S 118(3) creates security over property proceeds, ranking above mortgage bonds. S 118(1) is an embargo provision subject to a time limit. Jordan and others v. City of Tshwane Metropolitan Municipality, and others 2017, 6, SA 287, CC, S 118(3, is constitutional and does not transfer municipal debt to the new owner upon property transfer. Funeral and deathbed expenses. If the free residue cannot cover these expenses, the deficiency is paid from secured assets in proportion to their value, S 96(4). 2. Secured claims. After initial costs, the remaining proceeds are used to pay secured claims, including accrued interest, S 95(1). Interest up to 2 years before sequestration is secured, S 89(3). Interest from sequestration to payment date is secured at 8% per annum, unless a higher rate is contractually agreed, S 95(1). Read with S 103(2). Simple interest, not compound, Boland Bank Limited v. The Master and another 1991, 3 SA 387, A. Ranking of secured claims. Immovable property. 1. Enrichment lien. 2. Special mortgage bonds, recorded per the Alienation of Land Act. 3. Debtor-creditor lien, De Glazer and Sons, Proprietary, Limited v. The Master and another No 1979, 4, SA 780, C, Land en Landbouwbank van Zuid-Afrika v. Koopmanskloof Besproeingsraad 1992, 1, SA 217, A, 244. Movable property. 1. Enrichment lien. 2. Pledge, including statutory pledges under S30 of the Land and Agricultural Development Bank Act 15 of 2002. 3. Special notarial bonds, ranked by registration order. 4. Debtor-creditor lien. 5. Installment agreement hypothec. 6. Landlord's hypothec. _ Conflicts between security interests. Lien versus pledge cannot exist together, both require possession of the property. Landlord's hypothec versus other security cannot exist if the property is hypothecated by a notarial bond under the Security by Means of Movable Property Act 57 of 1993, unless perfected by attachment before bond registration. The property is subject to an installment agreement under S1 of the National Credit Act 34 of 2005. Deficient security proceeds. If the secured property does not fully cover the secured claim, the creditor can claim the balance as a concurrent creditor, unless they chose to rely only on the security proceeds. S16.1.2. Next. Page 16.3 Ranking of claims. Purpose: the Insolvency Act determines the ranking and extent of payments to various creditors from an insolvent estate. Estate distribution. Encumbered assets, proceeds pay secured creditors first. Any balance merges with unencumbered assets. Unencumbered assets, free residue, pays preferred creditors first, then concurrent creditors proportionally. Equal ranking: if preferred claims are equal and funds insufficient, claims abate proportionally. Post-sequestration interest: if funds remain after paying all creditors, interest is paid at a prescribed rate. _ 16.3.1 Encumbered assets. I. Initial costs, S89(1), paid before secured claims. Creditors cannot claim these from the estate. Standard Bank of South Africa Limited v. Townsend, and others 1997, 3, SA 41, W. 58. Includes maintenance and conservation costs, night watchman, auctioneer's commission, sectional title levies, S15B3, AI, AA, Sectional Titles Act 95 of 1986, Nel Novi Body Corporate of the Seaways Building, and another 1996, 1, SA 131, A. Barnett Novi Rikspersoon, Van Amini NN under 2001, 3, SA 973, SCA. Municipal clearance costs, water, sewerage, local authority fees, Eastern Metropolitan Substructure of the Greater Johannesburg Transitional Council v. Venten 2001, 1, SA 360, SCA, 370-1. Trustees' remuneration, determined by Tariff B, second schedule to the Act. Trustees' security costs, proportionate share. Masters' fees, third schedule to the Act. Tax due on immovable property. For 2 years before sequestration, S89(1). From sequestration to transfer, S89(1), including penalties and interest. Limitation of embargo provisions. Sequestration does not extend embargo periods in laws. Steve Tshweta Local Municipality v. Fedbond Participation Mortgage Bond Managers, Proprietary, Limited and another 2013, 3, SA 611, SCA. Municipal debt preference. Non-tax municipal debts, rates and services, rank above mortgage bonds under S118(3) of the Local Government, Municipal Systems, Act 32 of 2000, City of Johannesburg v. Kaplan No, and another 2006, 5, SA 10, SCA, 19-20. No time limit for municipal security under S118(3), while S118(1) imposes a time limit, City of Tshwane Metropolitan Municipality v. Mathabade, and another 2013, 4, SA 319, SCA. Historical debt and property transfers. Buyers are not liable for historical municipal debt under S. 118.3, Jordan and others v. City of Tshwane, Metropolitan Municipality, and others 2017, 6, SA 287, cc. 2. Funeral and deathbed expenses, S. 96.4, if the free residue is insufficient, secured assets contribute proportionately. Example, R. 600 deficiency shared, based on secured assets values, for example, R. 90,000 and R. 30,000 secured assets are 450, and are 150 contributions, respectively. 3. Secured claims, S. 95.1. After initial costs, remaining proceeds go to secured claims in order of preference. Interest on secured claims. 2 years before sequestration, treated as part of the capital, S. 89.3. After sequestration, payable at 8% PA unless a written contract specifies a higher rate, S. 95.1, S. 103.2. Only simple interest applies, Boland Bank Limited v. The Master and another 1991, 3, SA 387, A. Ranking of secured claims. Immovable property. 1. Enrichment lien. 2. Special mortgage bonds, recorded under Alienation of Land Act. 3. Debtor-creditor lien, De Glazer and Sons, Proprietary, Limited v. The Master and another No. 1979, 4, SA 780, c. Land en Landbouwbank van Zuid-Afrika v. Kopmanskloof, Besproeingsraad 1992, 1, SA 217, A. 244. Movable property. 1. Enrichment lien. 2. Pledge, including statutory pledges under S. 30 of Land and Agricultural Development Bank Act 15 of 2002. 3. Special notarial bonds, ranked by registration order. 4. Debtor-creditor lien. 5. Installment agreement hypothec. 6. Landlord's hypothec. Mutual exclusivity of certain security interests. Lien and pledge cannot exist together, both require possession. Landlord's hypothec is void if property is already hypothecated under a notarial bond, unless perfected before registration. Property is under an installment agreement, as per National Credit Act 34 of 2005. Shortfall in security, if a secured claim is not fully satisfied, the creditor ranks as a concurrent creditor for the balance. 16. 3-2 Unencumbered assets, free residue, ranking per SS 95 to 104 of the Insolvency Act. No deviation allowed, trustee must follow statutory ranking. Commissioner, South African Revenue Service v. Stan 29 North Winburg, Proprietary, Limited and others 2005, 5, SA 583, SCA. I. Funeral expenses S. 96.1, preference limited to R. 300. Covers funeral costs for insolvent, if he dies before first trustee's account is submitted. Insolvent's wife or minor child, if within 3 months before sequestration. 2. Deathbed expenses S. 96.2, preference limited to R. 300 in total. Includes medical attendance, nursing, and medical necessaries, S. 96.3. Claims rank pari passu and abate proportionally if needed. 3. Costs of sequestration, S. 97.1, Order of payment. 1. Sheriff's charges, for example, asset inventory. 2. Master's fees. 3. Miscellaneous charges, S. 97.2. Tax sequestration costs, includes opposition costs. Master's allowance for insolvency statement assistance. Curator bonus remuneration. Trustees' remuneration and administration costs, including security, executory contracts, litigation, estate protection, rent owed post-sequestration, salaries/wages of employees involved in administration. Miscellaneous charges rank pari passu and abate equally if funds are insufficient. 4. Special preferences under Companies Act 2008, Business Rescue Liquidation, Post-Business Rescue claims rank immediately after liquidation costs, S135(3). Business rescue practitioners' fees and expenses, unpaid remuneration and employment-related debts from business rescue, post-commencement financing claims, rank by order incurred. Section 135 preference continues after liquidation except for liquidation costs, S135(4). Further details on business rescue ranking in Section 27.3.2. Next. Page 16. 3.2 Unencumbered assets, free residue. The trustee must distribute the free residue according to SS 95-104 of the Insolvency Act. No agreement between the trustee and the insolvent can override the statutory distribution scheme. Case Law Commissioner, South African Revenue Service v. Stan 290 Winberg, Proprietary, Limited and Others 2005, 5, SA 583, SCA, Court held that an insolvent cannot prioritize one creditor over others outside the statutory order. Any private agreement must yield to the trustee's statutory duty. I. Funeral expenses. The first application of the free residue. Funeral expenses of the insolvent, if incurred before the trustee's first account submission. Funeral expenses of the insolvent's wife or minor child if incurred within 3 months before sequestration, S96(1). Preference capped at R300. 2. Deathbed expenses. After funeral expenses, the free residue covers medical expenses of the insolvent before the trustee's first account submission, medical expenses of the insolvent's wife or minor child if incurred within 3 months before sequestration, capped at R300, S96(2), includes costs for medical attendance, nursing, and medical necessities, S96(3). Claims rank pari passu and abate proportionally. 3. Costs of sequestration. The remaining free residue is applied to sequestration costs, S97(1). Order of payment. 1. Sheriff's charges, attachment and inventory costs. 2. Master's fees. 3. Miscellaneous charges, S97(2), including taxed sequestration costs, master's fee for preparing the statement of affairs, curator bonus remuneration, trustee's remuneration, costs of security for the trustee's performance, costs of maintaining, conserving, and realizing unencumbered assets, legal costs related to the estate, meeting expenses for creditors, rent owed after sequestration, wages/salaries of those assisting in estate administration. These costs rank pari passu and abate equally. 4. Special preferences under the Companies Act 2008, liquidation after business rescue, if business rescue transitions to liquidation, S135(3) of the Companies Act grants preference to business rescue practitioners' fees and expenses, unpaid remuneration of employees during business rescue, post-commencement financing, ranked in order incurred. Section 135(4). These claims remain preferred but are subordinate to liquidation costs. V. Costs of execution. If free residue remains after sequestration costs and Companies Act preferences. Sheriff's fees for executing against the insolvent's assets. Other taxed execution costs, limited to R50, S98(1). No preferential right is created by mere execution, S98(2). Vi. Salary or remuneration of employees. Free residue then applies to employee claims, S98(a)(1). Salary/wages, max R12,000 for up to 3 months. Leave pay, max R4,000 for the year of insolvency or preceding year. Other paid absences, max R4,000 for up to 3 months before sequestration. Severance/retrenchment pay, max R12,000. Employer contributions to pension, medical aid, UIF, etc. max R12,000 per scheme. Minister determines maximum amounts, S98(a)(2, last updated in 2000. Company directors and close corporation members are excluded from S98A benefits, GNR 865, Government Gazette 21519. Employees can claim without proving under S44, but may need to submit an affidavit, S98A3. Ranking of claims, S98A4. 1. Salaries/wages rank first. 2. Leave pay, paid absences, severance pay rank equally. 3. Employer contributions rank last. 7. Statutory obligations. Remaining free residue covers statutory debts, S99-1. Compensation Commissioner, Occupational Injuries and Diseases Act 130 of 1993. Withheld taxes, for example, pay, royalties, insurance benefits. Mines and Works Compensation Fund, Customs/excise duties and fines. National Supplies Procurement Fund repayments. VAT liabilities. UIF contributions. These debts rank pari passu and abate proportionally, S99-2. 8. Income tax. After statutory debts, the free residue pays income tax, S101. Covers income or profit tax and interest due before sequestration. 9. Claims secured by general bonds. Free residue then settles. General bondholders and special bondholders over movable property, registered before the 7th of May 1993. Extent of preference is limited to the net proceeds of the hypothecated assets, First Rand Bank Limited v. Land, and Agricultural Development Bank of South Africa 2015, 1, SA 38, SCA. If proceeds are insufficient, the remaining balance ranks as concurrent. X. Claims of concurrent creditors. Final stage, remaining free residue is distributed among unsecured, concurrent, creditors, S103(1)A. Secured creditors, for the part of their claim not covered by security. Preferred creditors, for the non-preferred portion of their claims. Creditors share proportionally based on their claim size. Interest on claims, S103(1)B. Any leftover funds after concurrent creditors are paid go toward interest. Simple interest at 8% per annum, or contractual rate, if higher. Interest applies from sequestration date to payment date. Case law. Boland Bank Limited v. The Master and another 1991, 3 SA 387, A. Simple interest only. Singer No v. The Master and another 1996, 2 SA 133, A. Secured creditors get full interest. Casey and another v. First Rand Bank Limited 2014, 2 SA 374, SCA. In Duplom rule applies. Interest stops accumulating once it equals principal. Next page. Chapter 17, the estate accounts and the distribution of the estate. _ 17.1 Estate accounts. Trustees' responsibilities. Realize assets and prepare estate accounts. Distribute proceeds to creditors as per the Act. Collect contributions if proceeds are insufficient. Types of accounts. S91, S93. Liquidation account records all receipts and expenditures. Trading account, prepared if business operations continue. Plan of distribution, details creditor payments. Plan of contribution allocates liability for deficits. Combined plan merges distribution and contribution details. Additional accounts. New accounts must be filed if further assets are recovered. A final account is not necessarily the last account before rehabilitation. Calls v. The Master and others 1998, 4, SA 212, C_. 17.1.1 Liquidation account. Contents, S92. Records all transactions except business-related transactions. Specifies amounts, dates and nature of transactions. Accompanied by bank passbook and supporting vouchers. If not final, must list. Unrealized property. Outstanding debts. Reasons for non-realization or non-collection. Separate accounts for partnerships, S92.5. Required for partnership and individual partner estates. Verification by trustee, S107. Trustee must sign and submit an affidavit confirming accuracy and full disclosure. Structure. Encumbered asset section covers secured assets, special mortgages, pledges, legal hypothecs, retention rights. Free residue section, free residue account, details proceeds of unencumbered assets and expenses paid from them. _ 17.2 Trading account. Required if business operations continue, S93. Includes only value of stock at sequestration and at the reporting date, daily receipts and payments, business profit or loss results. _ Next. Page 17 of 1.3 Plan of Distribution. Purpose displays how estate proceeds are distributed. Legal requirement, S94 must show parallel columns with secured/preferred claims, or portions thereof, unsecured/non-preferred claims, or portions thereof, amounts awarded to each creditor in the current and previous plans, deficiencies in each claim, customary format, claim number, as recorded at claim meeting, creditor's name, nature of claim, total claim amount, secured/preferred portion, concurrent portion, dividend awarded in current and past distributions, deficiency in claim, summation at the end of each column, totals are provided. _ 17 of 1.4 Plan of Contribution. I. Liability to contribute. When contributions are required. Deficiency in secured asset proceeds. Secured creditors must contribute pro rata, S89(1), shortfall in free residue for sequestration costs. All proven creditors contribute, S106. Sequestrating creditor must contribute even if no claim is proven, S14(3). First Rand Bank Limited v. Master of the High Court, Pretoria and others 2021, 4, SA 115, SCA 128. Preferred creditors who do not prove claims are exempt unless they choose to participate, S98A. 2. Liability of creditors ranking on free residue. Contributors. Concurrent creditors. Secured creditors entitled to share in free residue, if it existed, SS 106, 8312, 892. Secured creditors can prove against free residue for unpaid balances, S 832. Singano v. the Master and another 1996, 2, SA 133, Avoiding contribution, secured creditors can state in proof of claim that they rely only on security proceeds, S 892. 3. Sequestrating creditors' liability to contribute. Automatic contribution, S 14(3). Even if no claim is proved, the sequestrating creditor contributes as if a claim was proven. First Rand Bank Limited v. Master of the High Court, Pretoria and others 2021, 4, SA 115, SCA 130. Prevent sequestrating creditors from escaping costs, Edom 128. Applies in all sequestrations except voluntary surrenders or non-creditor liquidations. 4. Secured creditors' liability to contribute. Exemption: secured creditors relying solely on their security do not contribute unless no concurrent creditors prove claims, no other secured creditors rank on free residue, no sequestrating creditor is available to contribute. Possible additional liability: if contributions cannot be recovered from others, secured creditors may become liable under S 118(2). V. Unsecured but preferred creditors' liability to contribute. Legal interpretation, S 106. Covers secured and concurrent creditors, but also preferred unsecured creditors, Angevele Commissaries v. Die Meester en Ander 1989, 4, SA 69 T 76-77. Conditions for contribution. All proved creditors withdraw their claims. Cost incurred after last concurrent claim withdrawal. Bertelsmann et al. Mars, The Law of Insolvency in South Africa, 2019, para 22.4.5. No sequestrating creditor available to contribute. First Rand Bank Limited v. Master of the High Court, Pretoria and others. Vi. Form of Plan of Contribution. Legal requirement, S105, must show in parallel columns. Each claim liable for contribution. Amount each creditor must contribute. Customary format. Claim number. Creditor's name. Claim amount. Amount subject to contribution. Contribution payable. Next. Page 17.1.5 Combined Plan of Distribution and Contribution. A trustee may need to draft both a plan of distribution, for certain claims, and a plan of contribution, for others. Alternatively, a combined plan of distribution and contribution can be prepared. 17.2 Time within which accounts must be submitted. 17.2.1 Normal period. The trustee has 6 months from appointment to submit required accounts to the master, S91. If a final liquidation account is not possible, the trustee must submit periodic accounts every 6 months, S92-4. 17.2.2 Shorter period. If the trustee holds funds that should be distributed, the master may direct submission of an account before the prescribed period, S110-1. 17.2 Extended period. The trustee may apply for an extension before the prescribed period ends, S109-1. The application must include an affidavit detailing reasons for the delay, any required information about the estate, available funds or deficiency. A copy of the affidavit must be sent to all proven creditors, S109-1b. If the master refuses, the trustee may apply to court, S109-3. 17.3 Failure to submit accounts. If a trustee fails to submit accounts, the master or any interested party may issue a 14-day notice requiring submission, S109-2. The master can extend the deadline, but if refused, the trustee may apply to court, S109-3. If the trustee fails to submit accounts, provide supporting vouchers, comply with master's reasonable requests, the master or an interested party may apply to court for an order forcing compliance, S116-1. If costs are awarded against the trustee, they must be paid de bonis propria unless otherwise ordered, S116-2. 17.4 Examination of accounts by the master. The master must examine submitted accounts and their supporting documents. If claims are disputed, the master must ensure compliance with S45-3. Failure to properly consider accounts invalidates confirmation, Wilkins v. Potgieter No. 1996, 4, SA 936, T. 940. 17.5 Inspection of accounts by interested parties. Once approved, the trustee must advertise the accounts for inspection at the master's office, the magistrate's office in the relevant district, S108-1-2. A duplicate set must be sent to the magistrate, S108-1. Notice must be published in the Gazette, 1 Afrikaans and 1 English newspaper, S108-2, S43. The accounts must be open for inspection for 14 days after publication, S108-3. The magistrate must display a notice of receipt of the accounts, S108-4. Endorse a certificate of inspection after the period ends, S108-5. 17.6 Objections to accounts. Before confirmation, any interested party may file a written objection to the accounts with the master, S111-1. The master must consider the validity of the objection, direct amendments or issue other appropriate directions, S111-2. If dissatisfied with the master's decision, the objector may apply to court, S111-2a. If an amendment affects someone who did not object, the account must be re-advertised and reopened for inspection, S111-2b. The master may amend accounts on his own accord if he finds errors, improper charges, bad faith, negligence, or unreasonable conduct by the trustee, S111-2. 17.7 Confirmation of accounts. The master must confirm accounts if no objections were raised, objections were withdrawn or dismissed, the account was amended and re-advertised. Once confirmed, accounts are final unless set aside by a court. S-112. Grounds for reopening an account include fraud or reasonable error. PG Bison Limited v. Johannesburg Glassworks, Proprietary, Limited 2006, 4, SA 535, W, 540. Merit in reopening. Wispeco, Proprietary, Limited v. Herigold No 1983, 2, SA 20, C, 28. Once a dividend has been paid, accounts cannot be reopened, even for material errors. Gilby Distillers and Vintners, Proprietary, Limited v. Morris No 1991, 1, SA 648, A 656. Final confirmation does not prevent personal action against a trustee for fraudulent conduct. Commissaries van Binlands Inkomst v. Willers 1994, 3, SA 283, A 325-6. 17.8 Distribution of the estate. After confirmation, the trustee must advertise confirmation in the Gazette, distribute the estate, collect contributions from creditors where applicable. S-113-1, 3. 17.8.1 Payment of dividends. Trustees must submit creditors' receipts as proof of payment. S-114-1. Unclaimed dividends after 2 months must be deposited into the Guardian's Fund. S-114-2. 17.8.2 Collection of contributions. The trustee must include contribution details in the Gazette Notice, S-113-1. Notify each liable creditor by registered post, S-113-2, S-118-1. If a creditor fails to pay within 30 days, the trustee may obtain a writ of execution in the Magistrates' Court, S-118-1. Next page. Chapter 18 Composition. 18.1 Common Law Compromise. A debtor can avoid sequestration by reaching a compromise with creditors. Muhammad v. Lockhart Brothers & Co. Limited 1944, AD 230. 2 types. Common law compromise. Based on contract, requires unanimous approval. Preferred by creditors as it often results in a higher and faster dividend. Debtor benefits by avoiding sequestration consequences. Statutory composition, S-119 Insolvency Act. Requires approval of the majority of creditors, binding the minority. Does not discharge sequestration order. Debtor remains unrehabilitated but can apply for early rehabilitation. 18.4.5. Procedure. After a provisional sequestration order or before it, the debtor can propose a written agreement. Requires consent of all creditors and the provisional trustee, if appointed. The Witt v. Boathaven CC 1989, 1, SA 606, C. 611. If all creditors must sign for validity, any creditor can withdraw before full acceptance. Kopman and Another v. Benjamin 1951, 1, SA 882, W. If accepted and sequestration is discharged. Rights and obligations depend on the deed of composition and common law. If assets are sold, master's permission is required. Harrington v. Festa and Others 1980, 4, SA 424, C 18.2 Offer of composition, under Section 119. 18.2 Lot submission via trustee. Debtor's right. After the first creditors' meeting, the insolvent can submit a written composition offer to the trustee. S-119-1. Trustee's role. If creditors are likely to accept, the trustee must send a copy with the report to all proved creditors. S-119-2. If unlikely to be accepted, the trustee can reject it. S-119-3. But the insolvent may appeal to the master. Master's power. After reviewing the trustee's report, the master can order the trustee to circulate the offer. S-119-4. Creditors' meeting. Trustee must convene a meeting to consider the offer. S-119-5. Meeting must be held 14 to 28 days after sending the notice, S119-6. Notice must be published in the Gazette and newspapers, Mir v. the Master 1940 TPD 86, Illich v. Paginos 1985, 1, SA 795, A 18, 2 terms of composition. The offer can include any terms, such as the debtor regaining control of assets or being released from liability. Statutory requirements. Security provision. If the offer involves security, details must be specified. And sureties named, S119-7, Blue v. Lampert and Chipkin NNO 1973, 1, SA1, A. Equal treatment of creditors. Offer cannot favor one creditor over another, S119-7, 8. No condition linking to rehabilitation. A condition making the offer dependent on debtor rehabilitation is void, as the court has sole discretion over rehabilitation, S119-7. Underscore. Do you want me to continue with sections 18.3 to 18.5? Next. Page. Chapter 18 Composition. Underscore. 18.1 Common Law Compromise. A debtor facing financial difficulty or provisional sequestration can avoid insolvency by compromising with creditors. Mohammed v. Lockhart Brothers & Co. Limited 1944, AD 230. A common law compromise is based on contract and requires unanimous creditor approval, can be more beneficial for creditors due to early payment and cost savings, can help the debtor continue their trade, benefiting dependent creditors, releases the debtor from debts without sequestration consequences. If the compromise aims to discharge a provisional order, it must be accepted by all creditors. DeWitt v. Boathaven C.C., King and another intervening, 1989, 1, SA 606, c. A written agreement must be signed by all creditors. Any creditor can withdraw before full acceptance. Copman and another v. Benjamin 1951, 1, SA 882, W. If the compromise involves asset sales, the master's permission is required. Harrington v. Fester and others 1980, 4, SA 424, C underscore. 18.2 Offer of composition under Section 119. 18.2 Submission of offer to creditors via trustee. After the first creditors' meeting, the insolvent may submit a written offer to the trustee, S119-1. Trustee duties. If likely accepted, must send the offer and a report to every proved creditor, S119-2. If unlikely to be accepted, must notify the insolvent, S119-3. If the insolvent appeals, the master may instruct the trustee to send the offer, S119-4. The trustee must convene a meeting for creditors, setting a date between 14 to 28 days after notice is sent, S119-5, 6. The meeting is a general meeting under S41 and must be publicly advertised. Mir v. the Master and others 1940 TPD 86, Illich v. Paginos 1985, 1, SA 795, A 18, 2 terms of composition. The offer can include any terms but must comply with statutory restrictions. If security is offered, full details must be provided, S119-7, Blue v. Lampert and Chipkin NNO and others 1973, 1, SA1, A. The offer cannot unfairly benefit one creditor over another, S119-7, 8. An offer requiring the debtor's rehabilitation is invalid, as the court retains discretion, S119-7. Underscore. 18.3 Acceptance of Section 119 Composition. Acceptance requirements. Approved by creditors representing 3/4 in value and number of all proved creditors' votes, S119-7. Payment or security for payment must be made. The master issues a certificate confirming acceptance, S119-7. Secured creditors count only for their unsecured portion, S52-5. A creditor must prove their claim before voting, Mir v. the Master and others 1940 TPD 86. The resolution must be in good faith and benefit all creditors. Zulman and others v. Schultz 1924 TPD 24. 18.4 Consequences of Section 119 Composition. 18.4.1 All concurrent creditors bound. The composition binds all concurrent creditors, even those who did not prove claims or voted against it. S. 121, Illich v. Paginos 1985, 1, SA 795, A. Secured creditors' rights remain unaffected. Sureties of the insolvent are not discharged. S. 123. 18.4 To restoration of property to insolvent. If the composition terms provide for property return, the trustee is divested of it by operation of law. S. 122, Lorino v. Mammon 1952, 3, SA 194, N. Only specified assets revest, the rest remain under trustee control. Moodley v. Mill No 1965, 1, SA 154, D 18.4.3 Restoration of property to solvent spouse. Creditors of the solvent spouse are not bound. Upon acceptance, the trustee must restore the solvent spouse's vested property. S. 122. Creditors holding movables as security regain possession, and any realized security proceeds must be distributed according to rights. S. 122. 18.4.4 Trustees' duties. Must frame a liquidation account and distribution plan for creditors. S. 123.2. All payments must go through the trustee, except when a creditor fails to prove their claim before final distribution. S. 123.1. A creditor who delays proving their claim can recover their portion directly from the insolvent within 6 months after account confirmation. S. 123.1. Trustee must still investigate pre-insolvency transactions and report to creditors. S. 81.1. 18.4.5 Right to prompt rehabilitation. Normally, an insolvent must wait before applying for rehabilitation. Immediate rehabilitation is possible if the composition provides for at least 50 cents per rand to concurrent creditors. The master issues a certificate confirming compliance. S. 124.1. 18.5 Illegal inducement to accept composition. It is a criminal offense to offer or accept benefits in exchange for accepting or not opposing a composition. S. 141. Any such agreement is void. A person accepting such a benefit is liable to pay a penalty equal to the value of their proved claim, the amount of the benefit received, the amount received under the composition. S. 130. The trustee or any creditor, on indemnifying the trustee, may recover the penalty. S. 131. Next page. Study notes. Section 119 Composition in Insolvency Law. 18.3 Acceptance of Section 119 Composition. A binding composition requires acceptance by at least 3/4 in value and number of all proved creditors. S. 119.7. Payment or security for payment must be provided, as specified in the composition. IBID. The insolvent is entitled to a certificate from the master confirming acceptance. IBID. Voting rights. Secured creditors vote only on the unsecured balance of their claim. S. 52.5. Creditors who have filed claims. S. 44. Can prove them and participate in discussions and voting. Acceptance must be in good faith and in the interest of creditors. Invalid if based on pity or benevolence towards the insolvent. A collateral objective, such as benefiting the insolvent personally. Zulman and others v. Schultz 1924 TPD 24. A dishonest belief that the compromise benefits the estate. Mir v. the Master and others 1940 TPD 8694. 18.4 Consequences of Section 119 Composition. 18.4.1 All concurrent creditors bound. Binding effect. Applies to the insolvent and all unsecured, concurrent, creditors, even those who did not prove their claims. S. 121. Creditors are bound even if they voted against the composition. Illich v. Parginos 1985, 1, SA 795, A, 803-4. The composition is a statutory novation, replacing previous claims with new rights determined by its terms. Ibid. Surety liability. The composition does not affect a surety's liability. S 123. 18.4. To restoration of property to insolvent. If the composition specifies property restoration, the trustee is divested, and the insolvent revested by operation of law. S 122. No formal transfer or delivery is required. Lurie Novi Mamam 1952, 3, SA 194, N. Estate assets not covered by the composition remain vested in the trustee. Ibid. Post-sequestration assets. If composition terms allow, assets acquired post-sequestration become the insolvent's property. Ex parte Nyberg 1929 CPD 362. If not, they remain with the trustee. Moodley No v. Mill No 1965, 1, SA 154, D, 160, CF Ex parte Van, the Merva 2008, 6, SA 451, W, 457. 18.4.3 Restoration of property to solvent spouse. The composition does not bind creditors of the solvent spouse. Once accepted, the solvent spouse's property must be restored. S 122. Movable property held as security must be restored to the creditor. Ibid. Proceeds from realized security must be distributed according to rights. Ibid. 18.4.4 Trustees' responsibilities. Framing accounts and administration. The trustee must prepare a liquidation account and plan of distribution. S 123-2. These must comply with the Act's provisions on liquidation accounts. Ibid. Payments under the composition. Payments must be made through the trustee whenever possible. S 123-1. The trustee has no duty to creditors who fail to prove claims before final distribution. Ibid. Late creditors can claim directly from the insolvent within 6 months after confirmation of the relevant account. Ibid. Investigation of the insolvent's affairs. The trustee must investigate pre-insolvency transactions and report to creditors. S 81-1. The report is due within 1 month of composition acceptance. Ibid. 18.4.5 Right to prompt rehabilitation. Normally, an insolvent must wait before applying for rehabilitation. Immediate rehabilitation is possible if the composition ensures creditors receive at least 50 cents in the rand. S 124-1. A certificate from the master confirms compliance with this condition. Ibid. See also 19.2.1i. 18.5 Illegal inducement to accept composition. Criminal offense. Accepting a benefit for agreeing to, or not opposing, a composition is illegal. S 141. Any undertaking to induce acceptance of a composition is void. A person accepting such a benefit is liable to pay a penalty equal to the amount of their proved claim, if any, the value of the benefit received, the amount received under the composition. S 130. Recovery of penalty. The trustee may recover the penalty. S 131. If the trustee does not act, any creditor may proceed in the trustee's name after indemnifying them against costs. Ibid. Next page. Chapter 19. Rehabilitation. Synopsis. Rehabilitation enables an insolvent to make a fresh start, free from pre-sequestration debts and restrictions. It can occur automatically after 10 years, unless the court intervenes. By court order within 10 years, subject to conditions. Only the person of the insolvent is rehabilitated, not the estate. Insolvent estates do not get rehabilitated posthumously. Veengedezan Novi Sheikh and others 2014, 3 SA 14, KZD 16. 19.1 Automatic rehabilitation after 10 years. If an insolvent is not rehabilitated by court within 10 years from sequestration, they are deemed rehabilitated unless a court orders otherwise. S 127A1. Period starts from the date of provisional sequestration. Grevler v. Lansdowne NN Ander NNO 1991, 3, SA 175, t. If the court prevents automatic rehabilitation, the registrar must send a copy of the order to every registrar of deeds, S 127A2. Enter a caveat against any property transfers or bond cancellations, S 127A3. Keep the caveat in force until rehabilitation occurs, S 127A4. Underscore. 19.2 Rehabilitation by court within 10 years. The court has discretion to grant rehabilitation, ex parte Wolf 1958, 4, SA 190, n. The insolvent has no right to rehabilitation, ex parte Hittersay 1974, 4, SA 326, SWA. Court considers whether the insolvent should be allowed to trade freely, ex parte Haydenreich 1917 TPD 657-658. The nature of past business conduct, ex parte Fori, 2008, 4 all SA 340, D 348-9. Future financial behavior, ex parte LaRue 1996, 2, SA 419, C 423. Underscore. 19, 2.1 Circumstances in which rehabilitation may be sought. I. Composition of at least 50 cents in the rand. Immediate rehabilitation if the master certifies that creditors accepted a composition with payment/security of 50 cents per rand on concurrent claims, S 124-1. 2. Lapse of the prescribed period after confirmation of the first account. 12 months after the master confirms the first account, S 124-2A, with exceptions. 3 years if the estate was sequestrated before, S 124-2B. 5 years if convicted of fraud or insolvency-related offences under SS 132, 133, or 134, S 124-2C. 4 years if recommended by the master, S 124-2 Proviso, ex parte Porret 1991, 3 SA 866, N3, no claims proved after 6 months. The insolvent may apply if 6 months have elapsed since sequestration. No claims have been proved. No convictions for insolvency-related fraud. No prior sequestration, S 124-3. 4. Full payment of all proved claims. Rehabilitation allowed after confirmation of full payment of all proved claims, with interest and sequestration costs, S 124-5. The master must confirm the final distribution plan, ex parte Oosthuizen, 2012, for all SA 408, NWM, 411. If a secured creditor relies only on security, and it does not cover the full debt, they are not considered fully paid, ex parte Van Zyl 1991, 2, SA 313, C _. 19. 2 preliminary steps which must be taken. I. Notice of intention to apply. Different notice periods apply depending on the grounds of rehabilitation. Ground notice period method. Composition, 50C in the rand, 3 weeks advertise in the Gazette plus notice to trustee, S 124-1. Lapse of prescribed period 6 weeks advertise in the Gazette plus written, notice to master and trustee, S 124-2. No claims proved 6 weeks same as above, S 124-3A. Full payment of proved claims 3 weeks written notice to master and trustee, no Gazette notice required, S 124-5. Time is calculated excluding the first and last day, ex parte Douglas 1964, 4, SA 385, 0. Short notice may be condoned if the master/trustee had sufficient time, ex parte Royston 1948, 2, SA 1026, W, but not for Gazette notices, ex parte Van der Merwe 1963, 1, SA 268, O requirements for Gazette notice. Must follow Form 6 in the regulations, ex parte Van Blurk 1938 CPD 133. Details to be included. Estate number, insolvent's full name, identity number, DOB, address and occupation at sequestration, date of sequestration, date, time, and court of application, grounds for rehabilitation, for example, lapse of time, composition, etc. Errors in notice may invalidate the application, ex parte Sedema 1950, 2, SA 689, c. Court may condone omissions if no prejudice occurs, ex parte Mini et Uxor 1996, 3, SA 97, SE. _. 2. Security for costs. Insolvent must provide a 500 security for potential opposition costs, S125. Security must be lodged 3 weeks before the hearing, S125. Late filing is a fatal defect, ex parte Elliott 1997, 4, SA 292, W, _. Key cases cited. Ocar v. Pierce, 1986, insolvency applies to the person, not the estate. Veengadazan no v. Sheikh, 2014, death does not automatically rehabilitate the insolvent. Grevler v. Lansdowne, 1991, sequestration date determines rehabilitation timelines. Ex parte Wolf, 1958, rehabilitation is discretionary, not a right. Ex parte Forey, 2008, court examines past and future conduct. Ex parte LaRue, 1996, key concern is ability to obtain credit. Ex parte Porritt, 1991, master's refusal to recommend rehabilitation is reviewable. Ex parte Oosthuizen, 2012, payment must be confirmed in a distribution plan. Ex parte Van Blurk, 1938, incorrect Gazette notice invalidates application. Ex parte Elliott, 1997, failure to provide security is fatal. _. Summary. Rehabilitation clears pre-sequestration debts and restores financial standing. Automatic rehabilitation occurs after 10 years unless a court intervenes. Court-ordered rehabilitation can occur sooner, based on specific conditions. Court considers past financial conduct, future risk, and creditors' interests. Strict procedural requirements, for example, Gazette notices, security for costs. Errors in procedure can invalidate rehabilitation applications. Next. Page 19. 2-3 Trustees report to master. If the application is not due to full payment of creditors, the trustee must report to the master on any facts justifying refusal, postponement or qualification of the insolvent's rehabilitation, S124-4. The trustee is not entitled to a fee for this report, ex parte Thomas, 2002, for all SA 227, T, 229-31. _. 19. 2.4 Application for rehabilitation. I. Form and content of application. Application is made by notice of motion supported by affidavit. Founding affidavit must contain the following information, CFS 126. Insolvent's details: full name, address, and present occupation. Sequestration details, sequestration order details, trustee's appointment, and application made in the same court that granted sequestration. Ex parte Garvey 1924 OPD 108. Reasons for sequestration, CF ex parte Davis 1938, CPD 335. Insolvent's financials. Total assets and liabilities at sequestration date. Total claims proved, or statement that no claims were proved. Dividend paid, if any. Whether there are additional assets available for realization with an estimated value. Statement on surrender. Insolvent must declare full surrender of estate, and no secret agreements to induce the trustee/creditors not to oppose rehabilitation. Current financial position, assets, liabilities, and earnings at application date. Court assesses means to determine if additional payment is required. Ex parte Palmer and Palmer 1961, 1, SA 602 W. Full disclosure of household income, including income of spouse and dependents, ex parte de la Hague 1937, OPD 56. Basis for application and required circumstances. Composition. Affidavit must list creditors whose claims are unproven, including their details. Master's certificate must be attached. Lapse of time. Affidavit must prove S100, and 24(2) does not prevent application. If within 3 years of first estate account confirmation, must state. No prior sequestration. No conviction of fraudulent acts under S100 and 24(2)C, ex parte for Mark 1935 CPD 258. If within 4 years of sequestration, affidavit must state master's recommendation for rehabilitation, ex parte Albert 1937 CPD 276. No claim proved. Affidavit must confirm no claims were proved and that applicant has no S100 and 24(2)C convictions or previous sequestration. Payment in full. Affidavit must confirm master approved distribution plan under S100 and 24(5). Full disclosure required. Courts emphasize that rehabilitation is not a mere formality and requires full disclosure. Ex parte Koch 1983, 3, SA 700, SE 705, ex parte Fori 2008, 4 all SA 340, D 348. Failure to disclose all relevant details leads to dismissal. Grubb v. the Master and others 1999. 1 SA 746, C. In Grubb case, application was dismissed because the applicant failed to disclose foreign funds, did not explain reasons for sequestration, did not list creditors and amounts owed, did not explain discrepancies between his and his wife's financial statements. Publication of notice. Affidavit must confirm statutory notice was given. Gazette page and proof of service must be attached. Security under S125, proof, for example, registrar's receipt, must be attached. Affidavit attestation cannot be attested by the insolvent's attorney or any interested party. Cf. ex parte Van Zyl 1963, 2, SA 311, GW. _. 2. Master's report. Application must be served on the master in time for a report to be prepared. S127-1. Master's report usually incorporates the trustee's report. _. 3. Opposition to application. The following parties may oppose rehabilitation. S127-1. Master, trustee, any creditor, any interested person. Creditors, including those who purchase claims after sequestration, do not need court leave to intervene. Ex parte Harris, Fairhaven Country Estate, Proprietary, Limited as intervening party, 2016, 1 all SA 764, WCC. Opposing affidavits must be filed and served on the applicant. Applicant may submit replying affidavits. _. 4. Adjudication on application. Court requires the following documents: notice of motion and supporting affidavits, master's certificate, if based on composition acceptance, master's recommendation, if application is made within 4 years of sequestration, gazette notice and proof of service where applicable, proof of security lodged with registrar, master's report, opposing affidavits, if any, applicants replying affidavits, if any, court's discretion, S127-2. May refuse, postpone, or grant rehabilitation. May impose conditions if necessary. Next. Page 19.2 Rehabilitation of an insolvent. 19.2 Trustees report to master. If rehabilitation is not due to full payment of creditors, the trustee must report to the master on any facts that could justify refusal, postponement or qualification of rehabilitation. S124-4. No trustee fee is allowed for this report. Ex parte Thomas, 2002, 4 all SA 227, T. 229-31. 19. 2.4 Application for rehabilitation. I. Form and content of application. Brought via notice of motion supported by an affidavit. Founding affidavit must include S-126, ex parte Palmer and Palmer 1961, 1, SA 602, W. Full name, address, and current occupation of the insolvent. Details of sequestration order and trustee's appointment, ex parte Garvey 1924 OPD 108. Reasons for sequestration, ex parte Davis 1938 CPD 335. Total assets and liabilities at sequestration date. Total proved claims and any dividends paid to creditors. Whether further assets are available and their estimated value. Confirmation that the insolvent has fully surrendered the estate and not entered into any secret agreements. Statement of current assets, liabilities, and earnings to assess financial capability. Allegations establishing the basis for rehabilitation. Additional requirements for specific rehabilitation grounds. Composition, details of creditors, including those whose claims are unproved. Master's certificate must be attached. Lapse of time. Must show compliance with S-124-2 and confirm no prior sequestration or fraudulent conviction, ex parte for Mark 1935 CPD 258, ex parte Albert 1937 CPD 276. No claim proved must state that no claims have been proved and confirm no prior sequestration or fraudulent conviction. Payment in full must confirm master's approval of a distribution plan satisfying S-124-5. Additional disclosures. All material facts that might affect the court's decision, ex parte Koch 1983, 3, SA 700, SE 705, ex parte Fori, 2008, 4 or SA 340, D 348. Ex parte Grubb v. the Master and Others 1999, 1, SA 746, C. Court dismissed an application due to lack of candor and incomplete disclosures. Proof of required notices, Gazette publication, notices sent to the master/trustee. Proof of security provided under S-125. Affidavit must not be attested by the insolvent's attorney or an interested party, ex parte Van Zyl 1963, 2, SA 311, GW. 2. Master's report. Master must report to the court based on the application, S-127-1. Usually includes the trustee's report. 3. Opposition to application. Master, trustee, creditors, or interested parties may oppose, S-127-1. A creditor who purchased a claim post-sequestration does not require court leave to oppose, ex parte Harris, Fairhaven Country Estate, Proprietary, Limited as intervening party, 2016, 1 or SA 764, WCC. Opposing affidavits must be filed with the registrar and served on the applicant. 4. Adjudication on application. The court considers notice of motion and supporting affidavits, master's certificate for composition-based applications, master's recommendation for early rehabilitation under S-124-2, Gazette notice, proof of required notifications, proof of security lodged, master's report, opposing and replying affidavits. Court may refuse, postpone, or grant rehabilitation under conditions, S-127-2. Underscore. 19, 2.5 Court's discretion. Rehabilitation is solely within the court's discretion, exercised judicially, ex parte Phillips 1938 CPD 381-384, ex parte Fori, 2008, 4 or SA 340, D. 343. Court must consider the master's and trustee's opinions and evaluate all relevant facts before deciding. Time lapse alone does not justify rehabilitation, ex parte Fori Supra 343. I. Postponement of rehabilitation. Reasons for postponement. Need for more information, ex parte Isaacs 1952, 4, SA 128, 0. Pending criminal proceedings, ex parte Jos Allowance 1957, 2. SA 120, W. Need to allow late proof of claims, ex parte Snoop 2014, 5. SA 426, FB. Insolvents misconduct, for example, false statements, reckless financial conduct, ex parte Rupert 1947, 1. SA 147, C. Ex parte Hitase 1974, 4. SA 326, SWA. 2. Grant of rehabilitation subject to a condition. Court rarely imposes conditions unless special circumstances justify it. Ex parte Minor 1937 CPD 154, Ex parte Cutting 1943 CPD 51. Examples of conditions: payment of trustees' fees and creditor claims, ex parte Matthew 1975, 3, SA 804, 0. Increased dividend to creditors, ex parte Ruse 1955, 1, SA 572, 0. Consent to judgment for unsatisfied debt balances, S 127.3, ex parte Goshalia 1957, 2, SA 182, N. 3. Refusal of rehabilitation. Grounds for refusal include negligent business conduct, ex parte Bloomberg 1914 EDL 1. Failure to keep books of account, ex parte Hagi 1939 NPD 197. Excessive pre-sequestration debts, ex parte Eza 1934 CPD 65. Non-cooperation with trustee, ex parte Martins 1951, 4, SA 530, N. Obstructing estate administration, Grubb v. the Master and others 1999, 1, SA 746, C. Living in luxury without creditor payments, ex parte Porritt 1991, 3 SA 866, N. Failure to disclose all insolvency-related circumstances, ex parte Davis 1938 CPD 335, ex parte Fori. 2008 for all SA 340, D. 343-348. No indication of learning from insolvency, ex parte LaRue 1996, 2, SA 419, C. Reckless debt accumulation, ex parte Du Toit 1964, 3 SA 159, T. Court may specify when a new application can be made or leave it to the insolvent's discretion, ex parte Part Supra. 4. Considerations in favor of unconditional rehabilitation. Minimal debts, ex parte Mark 1932 WLD 5356. Sequestration due to misfortune, ex parte Minor 1937 CPD 154. No creditor action under S235, ex parte Jacobs 1977, 4, SA 155, North Carolina. No opposition from creditors, trustee, or master, ex parte Van Staden 1967, 4, SA 375, R_. 19. 2.6 Illegal inducement not to oppose rehabilitation. Criminal offense to accept a benefit for not opposing rehabilitation, S 141. Any agreement to induce non-opposition is void. Penalty for acceptance equals amount of claim, proved plus value of benefit, S 130. Trustee may recover benefit, if not, a creditor may sue in trustee's name, S 131. Next. Page 19, 2.5 Court's discretion. Rehabilitation of an insolvent lies within the court's discretion, exercised judicially, ex parte Phillips 1938 CPD 300, and 81-384, ex parte Fori, 2008, for all SA 340, D. 343. Court considers previous cases, the master's and trustee's opinions and available facts. Lapse of time alone is insufficient to justify refusal of rehabilitation, ex parte Fori, Supra, 343. I. Postponement of rehabilitation. Court may postpone the application if More information is required. Ex parte Isaacs 1952, 4, SA 128, 0. Criminal proceedings against the insolvent are pending. Ex parte Jos Allowance 1957, 2, SA 120, W. Creditors were not properly notified or lacked information to assess risk. Ex parte Snoop 2014, 5, SA 426, FB. Applicant misconduct warrants disapproval. Ex parte Rupert 1947, 1, SA 147, C. Ex parte Hittersay 1974, 4, SA 326, SWA. Court aims to impress upon the insolvent the gravity of insolvency and their responsibility towards creditors. Ex parte Hittersay, Supra 328. 2. Grant of rehabilitation subject to a condition. A condition is imposed only in extraordinary circumstances. Ex parte Minor 1937 CPD 154. Special circumstances must justify imposing a condition. Ex parte Cutting 1943 CPD 51. Examples: blameworthy conduct before/during insolvency plus ability to pay. Ex parte Mappy 1975, 3, SA 804, 0. Failure to cooperate with trustee after sequestration. Ex parte Ruse 1955, 1, SA 572, 0. Court may order payment of trustees' fees or increase dividends to creditors. Insolvent's financial ability alone is not enough to impose payment conditions. Ex parte Fowler 1937 TPD 353-357. Section 127(3). Court may require the insolvent to consent to judgment for unpaid debts, enforceable only with court leave upon proof of available property/income. Section 127(4). Rehabilitation under a composition may preserve pre-sequestration obligations. Example: insolvent may be required to refund creditor contributions. Ex parte Goshalia 1957, 2, SA 182, N. 3. Refusal of rehabilitation. Court may refuse rehabilitation if the insolvent ran business improperly/negligently. Ex parte Bloomberg 1914 EDL 1. Failed to keep proper records. Ex parte Hagee 1939 NPD 197. Recklessly incurred excessive debts. Ex parte Ezra 1934 CPD 65. Obstructed trustees' administration. Ex parte Martins 1951, 4, SA 530, N. Grubb v. The Master and Others 1999, 1, SA 746, C. 749. Lived luxuriously without contributing to creditors. Ex parte Porritt 1991, 3, SA 866, N. Withheld information about insolvency. Ex parte Davis 1938 CPD 335, Ex parte Forey, 2008, for all SA 340, D. 343-348, showed no awareness of insolvency's impact on creditors. Ex parte LaRue 1996, 2, SA 419, C. Had an excessive debt-to-asset ratio plus other negative factors. Ex parte Du Toit 1964, 3, SA 159, T. 161. Refusal may include a waiting period before reapplying. Ex parte Porritt, Supra. 4. Considerations in favor of unconditional rehabilitation. Factors supporting unconditional rehabilitation. Small debts. Ex parte Mark 1932 WLD 5356. Sequestration due to misfortune rather than misconduct. Ex parte Minor 1937 CPD 154. Creditors or trustees did not enforce their right to insolvent's earnings. Ex parte Jacobs 1977, 4, SA 155, North Carolina. No opposition from creditors, trustees or master. Ex parte Van Staden 1967, 4, SA 375, R 19, 2.6 Illegal inducement not to oppose rehabilitation. Criminal offense to accept benefits for not opposing rehabilitation. Section 141. Agreement to grant a benefit in exchange for not opposing rehabilitation is void. Person accepting a benefit must pay a penalty to the estate equal to the claim amount they prove against the estate. The value of the benefit received, Section 130. Trustee may recover the benefit. If they do not, a creditor may sue in the trustee's name, Section 131. Next. Page 19, 2.5 Court's discretion. Rehabilitation is solely at the court's discretion, exercised judicially, ex parte Phillips 1938, CPD 381-384, ex parte Fori, 2008, 4 or SA 340, D. 343. The court considers the master and trustee's opinions but can decide independently. Lapse of time alone does not justify refusal of rehabilitation, ex parte Fori, Supra, 343. I. Postponement of rehabilitation. Court may postpone the application if more information is needed, ex parte Isaacs 1952, 4, SA 128, 0. Postponement is possible when criminal proceedings are pending, ex parte Joselowitz 1957, 2, SA 120, W. Application may be delayed if claim proofs were not properly handled, ex parte Snoop 2014, 5, SA 426, FB. Postponement may serve as a reprimand for dishonest conduct, ex parte Rupert 1947, 1, SA 147, C, ex parte Hittese 1974, 4, SA 326, SWA. 2. Grant of rehabilitation subject to a condition. Conditions imposed only in extraordinary circumstances, ex parte Minor 1937 CPD 154, ex parte Cutting 1943 CPD 51. Special circumstances must justify imposing a condition, ex parte Theron N.N. Ander, ex parte Smith, ex parte Webster 1999, 4, SA 136, 0. Examples. Insolvents blameworthy conduct before insolvency, ex parte Matthew 1975, 3, SA 804, 0. Failure to comply with Insolvency Act obligations, ex parte Ruse 1955, 1, SA 572, 0. Court cannot impose a payment condition just because the insolvent is financially capable, ex parte Fowler 1937 TPD 300. And 357. Section 127(3). Court may require judgment for unpaid debts, but execution requires court approval. Section 127(4). Court may uphold pre-sequestration obligations despite rehabilitation. Example: insolvent ordered to pay creditors before rehabilitation is granted. Ex parte Goshalia 1957, 2, SA 182, N. 3. Refusal of rehabilitation. Factors for refusal. Improper/negligent business conduct. Ex parte Bloomberg 1914 EDL 1. Failure to keep proper books. Ex parte Hagee 1939 NPD 197. Reckless debt accumulation. Ex parte Eza 1934 CPD 65. Non-cooperation with trustee. Ex parte Martins 1951, 4, SA 530, N. Obstructive behavior against estate administration, Grubb v. the Master and others 1999, 1, SA 746, C. 749. Living luxuriously without creditor contributions, ex parte Parrott 1991, 3, SA 866, N. Failure to disclose circumstances of insolvency, ex parte Davis 1938 CPD 335, Grubb v. the Master and others, Supra, 751-3. Concealment of past insolvency and criminal record, ex parte Fori, 2008, for all SA 340, D. 343-348. No evidence of learning from insolvency, ex parte LaRue 1996, 2, SA 419, C. Large excess liabilities over assets alone does not justify refusal, unless accompanied by reckless debt accumulation. Ex parte du Toit 1964, 3, SA 159, t. 161. Court may specify when reapplication is possible but may also leave it to the insolvent's discretion. Ex parte part, supra. 4. Considerations for unconditional rehabilitation. Factors in favor. Small debts incurred, ex parte Mark 1932 WLD 5356. Insolvency due to misfortune, not fault, ex parte minor 1937 CPD 154. No attempt by creditors to claim the insolvent's earnings, ex parte Jacobs 1977, 4, SA 155, North Carolina. No opposition from creditors, trustee or master, ex parte Van Staden 1967, 4, SA 375, R_. 19. 2.6 Illegal inducement not to oppose rehabilitation. It is a criminal offense to offer/accept a benefit for not opposing rehabilitation, Section 141. Agreements to induce non-opposition are void. Person accepting a benefit must pay a penalty to the estate, equal to their proved claim amount, if any, the value of the benefit received, Section 130. Trustee can recover the benefit. If not, a creditor may sue on behalf of the trustee, indemnifying him against costs, Section 131. 19.3 Effect of rehabilitation. N. Sequestration, removes disabilities and discharges debts, Section 129(1). Exception, fraud-related debts remain payable. Discharges even foreign debts enforced by a post-sequestration foreign judgment, North American Bank Limited, in liquidation, v. Granit 1998, 3, SA 557, W. 565-7, ex parte Van der Merwe 2008, 6, SA 451, W. 458, does not affect rights/duties under a composition, liability of a surety for the insolvent, criminal penalties, Section 129(3). Property and estate vesting. Insolvent does not automatically regain his former estate unless a composition provides for reinvestment, Section 122. No claims were proved within 6 months of sequestration, Section 129(2). Property not distributed remains vested in the trustee, Section 25(1). Immovable property registration becomes valid if caveats lapse, Section 25(3). Trustee can only recover the value of such disposed property, Section 25(4). 19.4 Declaratory order regarding property. Insolvent may apply for a declaratory order if creditors/trustee make no claim to an asset. If successful, court may order revesting of the asset, ex parte Parker 1946 EPD 536, ex parte Creel 1949, 1, SA 971, 0975, ex parte Van der Merwe 2008, 6, SA 451, W. 461-2. Court may find creditors and trustee waived their rights by not claiming the asset, ex parte Olivier 1948, 2, SA 545, C. 554. Requirements for a declaratory order. Insolvent must publish a notice in the Government Gazette detailing the property, serve notice on the master, trustee, and creditors, show efforts to trace uncontactable creditors, provide full disclosure that the property was acquired adversely to the trustee, ensure no creditor objects, Forster v. Stein no en Ander 1981, 2, SA 831, O revesting order example. Ex parte Van der Merwe supra. Property, vacant land, excluded from liquidation due to excessive rates and taxes. Only one creditor proved a claim. Insolvent repaid the contribution and outstanding rates before applying. Court granted revesting as there was no creditor prejudice. Court acknowledged full disclosure and payment of outstanding debts as factors in favor of the order.